Okay, so I'm going to step off the stage here, and I will play the part of Phil Donahue. Okay, so now I'll see how old some of you are. Who knows who Phil Donahue is?
I don't.
Okay, Renee definitely knows. I know how old she is. So I'll be the roving Phil Donahue with the microphone in your face. My good friend John White, who happens to be famous, as many of you know. He taught patent, and continues to teach patent bar review. He's taught at least, he says, what's your
33,000.
Okay, it's closer to 40 to 45,000 students, I think. He's really impacted many of you, and I know many of you. Many of you have taken the course and have sat through our lectures. John created the course many years ago, and he's a patent expert, testifying expert. He does patent work still. He's with Harness and Dickey, and he is my very good friend. And a little known fact about John: John was my best man in our wedding. So John and I have been friends for many, many years.
This is my fault.
Yes, right. So John is my work wife. So, but with that, John is also, as it turns out, an extremely rah-rah fan of the unitary patent and the unitary patent court. So I've asked him to moderate this panel, which is going to be a conversation about we styled it Germany versus the UPC. It's really Germany has influenced the UPC in an awful lot of ways. So we're going to talk about the benefits of litigating in Germany. We're going to talk about the benefits of litigating at the UPC. And joining us for this panel, we have Judge Michael Fleuchaus, who is here not in his judicial capacity. He's a technical judge on the UPC. He's here as a lawyer to talk to us about that. He's here to talk to us descriptively about litigating in Germany, and to the extent there may be certain things that we really would like to ask him that you can try and you can ask him, but we're going to understand if he can't answer those questions about the UPC. So thank you, Your Honor, for being here. Next to him is Volkmar Henke, and whenever I put a judge on a panel, I always want to have a lawyer who litigates in the courts and knows the law, and Volkmar is an expert on patent pools. He does patent litigation both in Germany and the UPC. So anything Judge Fleuchaus doesn't want to answer, we'll ask Volkmar to answer procedurally. So Volkmar, gentlemen, both of you came from Germany a long way away. Thank you for being here today. And John, I'll leave it to you to take away.
All right, well, thank you, Gene. Yeah, the last thing I'll ask, Johnny Carson, anyone, because sometimes it's take it away, Johnny, but yeah, who's that? And Ed McMahon. What happened? Our cultural touchstones are melting. All right, so John White here, big fan of the UP and UPC. Now, just a quick show of hands, how many of you know what the UP is? How about, yeah, okay. UPC, yeah, more hands go up. Okay, all right. Well, let me. We live in a world and talk in a world of acronyms. That's us. And so let me give you just a quick rundown on what both of these things mean, where they came from, and how they exist, and then we'll go forward with our discussion. So let's get everybody on the same page, as they say. So Gene always says I like to go back to Mesopotamia and then start from there, but I'm not this time. I'm going only back to post-war Europe. Post-war Europe, we've seen a lot of political and economic coalescing, okay? And you see that in the form of the EU and participation there. But in patents, everything remained rather separate until about 1970, and that was a creation in and about that time of two things, the EPO and the PCT system. And for those of us who were not in Europe, it was always difficult to file in Europe because you had to make decisions about where you'd go, what you'd spend, what languages, what mattered to you, and so forth. And the EPO kind of made it simpler. At least you could start in one place. PCT made it even simpler still because that was a hedge before you even got to the EPO. And so on the application side, we had more coalescence than we've had on the enforcement side. You could start the patent application process at a single location, the EPO. Once done, you still had to register, extend, whatever, authenticate your rights in whatever country you wanted. You had to pay annuities and so forth in each one. But at least you could start in one place, hey? Work in one language until that time came. But enforcement was all over the place, and you had to go to the court in the land where you hoped to enforce it and find your defendants and so forth. And this works, but it is obviously a scattershot, right? Got to go wherever it is you can obtain jurisdiction and obtain enforcement. Well, for a long time, and beginning, I guess in the 1980s, at least there was talk of it, that they might have a pan-European enforcement tool, this unified patent court. But it didn't come into fruition, didn't exist. So what happened? Well, last year happened. What happened in the last year, June of 2023, we had two things burst onto the scene at the same time. One is the unitary patent. We call it the UP. This is a new right that is issued by the EPO. No next steps on your part. You just choose it at the time you get your indication of allowance from the EPO, and you have a patent right in 17 countries that are a member of the unitary patent system. Unitary patent. What's nifty about it is you don't have to do any translations but one, but it's not a legal translation, it's just into one other language. And then you have rights in all these countries, and the annuities are rather cheap, okay? Now, there's two wonderful things about the unitary patent. One is its low cost, which means now patents that might not otherwise have been filed can be, because it's not so expensive as it once was. It doesn't mean you have to bet the farm on this single right across 17 countries, because you can still go the route we are familiar with, which is to get your patent granted by the EPO and then register it, extend it, and so forth, and get your regular EP rights where you want. So you can choose, go either way. All right, so we have the unitary patent, UP, that's the first thing. Then we have the unified patent court. Well, what jurisdiction does it have? It has jurisdiction over this thing called the unitary patent and any EP issued patent that has not been opted out. Okay, so last year when this got going, you probably heard of this sunrise period, right? When people could presumptively or preliminarily opt out before the UPC got rolling, the Unified Patent Court. And so you saw many companies do that. That sort of shut down the case management system for a while, with so many people trying to opt out before the deadline and so forth. And the reason they're opting out is because this new court, Unified Patent Court, no one knows enough about it yet to make an informed decision about whether to stay in or to opt out. Well, here we are 1 year later, all right? And so we have some insight now from our two great speakers that we have here today. So understand that the UP and UPC go together, but not necessarily. The Unified Patent Court has jurisdiction over all the EP folks that didn't opt out. You don't have to opt out right away, but if a proceeding starts before you opt out, you're stuck. It's what we would call pick-a-lane jurisdiction. You're stuck if you don't escape, okay? So that's the Unified Patent Court. So Gene gave a partial introduction. We have a judge, we have a lawyer, but something you may not know is the judge here is also a lawyer and also is a partner in a private firm. How many judges in America maintain their private practice and work as judges? None, except local court judges, right? Once you get to the state and federal level, typically you make a decision. I'm going to be a judge or I'm going to be a lawyer, and most go and become judges. But here, he can continue as a partner in his firm and also be a judge on this Unified Patent Court. And so he was qualified late last year, and both of them are physics. I don't know what this means, but both of them are physics people, so we'll see what insight that brings. Now, for purposes of theatrics, as Volkmar said, he's going to be the bad guy. He's going to say this is not a good thing, but just for purposes of theatrics, he says. And of course, Judge Fleuchaus is a big fan of the UPC, but I should tell you that I am too. All right, so we've gotten a look at a very high level with respect to where the Unified Patent Court came from. We've been at it now 1 year. So, Judge Fleuchaus, give us your summary of the system, how it's working, the advantages, disadvantages, some stats if you have them on how it's working.
Thanks, first of all. So I think one of the major differences that everybody may need to understand is that the Unified Patent Court, it's a central court, but it doesn't have a courthouse. So it's called a disembodied court, meaning that while it's a central court, while it makes decisions for 17 member states, these chambers are distributed across Europe. So every major capital has a chamber, or many of those have a chamber, and they are all connected by what you just mentioned, the case management system. It's a fully electronic case management at the Unified Patent Court. You will rarely see any paper. There were a couple of papers filed in the beginning because the electronic system went down, but ever since then, everything has been mostly sorted out, at least from that perspective. And so there is not a single piece of paper. In theory, judges are distributed all over the place in Europe. In fact, the panels will be put together from judges across Europe, depending on language and technology. And yeah, we have the concept of distribution and centralism at the same time, which sounds a bit like a contradiction, but it works so far. The idea behind the Unified Patent Court was, of course, to bring in a new system, so don't take just the German system or just the British system or any other system and impose that on the entirety of Europe. But they have picked and chosen, I think, mainly the good parts from these individual jurisdictions, like something from the Germans, something from the French, and other jurisdictions. The Germans, for example, have chipped in, I believe, the technical judges. So, as you all know, most of the time, courts do not have a technical judge on the panel. And that has been practiced in Germany at the German Patent Court, which oversaw validity issues of patents. It was quite well received, and I think it was quite accepted as a good court. And so that was one of the things that I believe the Germans added to the whole system, was the idea of the technical judge on the panel, both to make the panel more efficient and not having to deal with iterations of expert opinions and maybe a lot of bonkers arguments being made, but have somebody on the panel who understands what's being said right away. And that also led to, for example, another thing that was quite common in Germany. We had bifurcation in Germany for validity, and at the same time you had infringement procedures. And that was, while it's still in the agreement that this is possible, it seems that there's not much use being made of it. So most of the procedures, in fact, I think all of the procedures at the moment currently pending have infringement procedures and invalidity procedures before the same chamber. That's not a big deal for you because you're used to that. For us as Germans, that has been a novel thing. We always had bifurcation. We learned to live with bifurcation, but it's not the best idea. And we've had several issues in relation to bifurcation, of course, that had to be resolved, could be resolved, but it was complicated. Now at the Unified Patent Court, because of the technical judges on the panel, I think it was okay to at least think of the idea of having both these procedures in front of the same panel. And maybe also because of this, the court will be, at least I hope, will be more successful making better educated, more educated decisions at a faster pace. Efficiency is one of the big goals of the court that has already trickled down in some decisions. The rules of procedures are tailored to force the parties to be efficient. And what I find most striking is that the court issues decisions that are immediately effective for all the countries, for all the member states. So no more acceptance procedures in the member states or whatever. But if you get a decision from the Unified Patent Court, you go see your bailiff and you execute in any of those 17 countries. That has possibly, that's the reason why the Unified Patent Court has so far had a rough 20% of intermediary injunctions requests, and they are being executed. So you can get an injunction before the Unified Patent Court quickly and execute that on a large scale. And that includes seizure requests, that includes preservation of evidence, and injunctions to cease and desist. The bar for this, for an intermediary injunction, has been chosen or decided to be chosen quite reasonably, and the main focus is it must be more likely than not either infringed or valid, and that would be the bar for the intermediary injunction to be granted or not. I think in comparison to the German system, there are a couple of differences and a lot of overlapping things. One that's certainly different is that the German chambers, for example, and in many other countries, the chambers do actually hear cases in English language. So in France or at the Paris local chamber and central chamber, in Munich, in Mannheim, in Düsseldorf, everywhere you get your procedure in English language if you file in English.
Wow.
So that is maybe one of the main differences compared to all those national procedures, which are usually in the national language. And that, to me, would be the most important things to mention.
Yeah, no, I think it's, as I've said, it's a terrific thing. And, German procedure and law, patent law, writ large across Europe, I would say is not a bad thing, if that's how it turns out. Okay, so Volkmar, all this goodness, you get to be the Darth Vader here and tell us how this could all go horribly wrong.
Thank you. Thank you very much. I am.
Yes, Darth. Go ahead.
I am not sure how long I will be able to play this role, because at the very end, and we will certainly come to it, I'm also a fan of the system. I'm very much thrilled to be part of these first days of the new system. But also from now I start with a personal perspective. We are losing something, and this leads me back to the panel which we had yesterday evening. Was it Judge Michael or Judge Rader? He says that they have observed a general tendency in patent litigation that the core things like claim construction, infringement, validity are getting a little out of sight, but we are more and more talking about procedural issues. And this is now maybe the worst thing I can say about the new system. This is exactly now the case which we are seeing in our first cases in the first year. We are having a huge overhead of procedural struggles. We will come to it. The service, appeal possibilities, all this new procedural law must be developed now by the judges, by the courts, and also by the attorneys. And you also have to have clients which are supporting all this crazy overhead, procedural overhead, I would call it. And that's why now, starting from this personal perspective, what are we losing? We are losing these very lean, front-loaded, but very paper-based, quick German proceedings. For the moment, we have a lot more to do, and the clients have to pay more for the time being. The deadlines, as Michael said, are very strict, and they are so strict that you can't just do it as we did it before in Germany with 1 or 2 people on the attorney side on a case. We now have, if you just looked even to the plaintiff side for an infringement case, then you always say you can prepare your case, you have time to prepare the statement of case, and then the defendant has on the paper it looks like 3 months, in the practice it's more like 5 months. But then the ball comes back to you as the plaintiff, and you have 2 months to prepare your rebuttal, or it's called a reply to the statement of defense. And at that time, you have really to re-tailor your case. You have to do, amend the claims. If possible, later options are not there due to this efficiency. And you can't do this with what we have been using in Germany, these lean small teams without paralegals. Now you have to team up. But of course, I mean, this is the counterweight against this immense impact which we now have. Judgments, as you said, of this court are valid in all countries which are participating for the moment. You said 17, is that
Yes.
the actual number? And this is maybe now practically, now I'm speaking to the good for the court. Effectively, the first real practical option to get an injunction in more remote countries which did not have such developed patent courts as we had in the UK and Germany or France,
Right.
Netherlands. So yes, I would say to Judge Rader and Judge Michael, yes, this is in particular now the problem of the UPC in practice. My good hope is that these are only teething problems of the first round, and sometimes I wish to push the fast forward button and see where we are in 5 years from now when all this dust has a little settled. But for the moment we are disputing, we are battling us about really strange little procedural issues.
Right, right. Yeah, that's a funny story, because one of the first filings in the Unified Patent Court, the issue became who got there first, and the electronic system had crashed, and the person with the paper who filed it in person won the day because they were hours ahead of the system coming back to life. So, yeah, sometimes paper can win, but yeah, the procedural thing, it was kind of funny that right out of the gate they had one of those interesting issues.
But this is, I think, really one show pony there. This was for the 1st of June last year.
Yeah.
I think the CMS, this electronic filing system, is really a pain for everybody, and it adds 25% of additional work just to cope with the technical issues. But it is stable. That is what we can say. It's stable but bad.
Yeah, it works for now. Yeah. Now, all of us here in America have been the beneficiary of the victim, as they say, of a new court at one time or another. When I was getting going in my career, it was the CAFC. Remember those wonderful days? Judge Markey never saw a patent he didn't like. Big money for everyone. Okay, and now more recently, what do we think of the CAFC? I'm for TV people, I won't give you the show of hands, but thumbs up, thumbs down on 101, huh? Anyone? Let's just add, thumbs up on 101. I see no thumbs. Okay, so, we've been the beneficiary and the victim, right, of what a new court can do, and then more recently, the PTAB, right? On paper, what a great idea, okay? In practice, wow, don't want to be a patent owner there, do ya? Doesn't seem to work out. So we understand what it is to experience a new fix, as it were, for problems that we had. So let me just, out of the gate, what was the perceived problem or problems that the UPC was intended to fix? And then once you characterize them, do you see that being fixed, or has it been fixed? Go ahead, Judge Fleuchaus.
The main thing is just scattering, as you say, a scattershot of procedures you had to go through. If you wanted an injunction throughout even only the main countries of the European Union, like the main markets of the European Union, you had to go through 5, 6, 7 procedures, potentially with differing outcomes. I mean, the European patent, the bundle patent, could have been stayed valid or amended or invalidated. Everything was possible in 3 different countries. So that, for once, is I think, a big improvement that you don't get these contradicting decisions and different procedures. It was also very costly, of course. If you go through court in 5-6 countries, that's not cheap and probably much more expensive than what you would spend on a larger team in front of the Unified Patent Court right now. Those two issues alone, I think, justify the institution of a court for a patent that was meant to be a single type patent. I mean, the European bundle patent was never really a single patent, but it had the notion of being a single patent, and in very many cases it had the same claim applicable to all the countries. There were rare exceptions, and those can't be turning into a unitary patent. But for most of the cases, you would be dealing with the same claim, with the same claim language, albeit in different languages, and with different procedures, different legal systems, in the end, potentially different results. And then you had to go through execution or get the bailiff in every one of those countries and deal with the national specifics to execute your decisions. And that in itself was mind-boggling. So I think now a lot of these complications have been removed. And yes, there are complications added, of course. The system isn't trivial. It requires a decent amount of knowledge. It requires a larger team. And it's more expensive, of course, to start with. But once the teething problems have been settled, I think a lot of it is going to be pretty smooth. Everybody is expecting it to be pretty smooth, and I don't believe that these funny fights about whether or not where it was filed first and so on. I mean, that's a question you answer once and then you're done, and then you move on. So it'll be smooth.
And Volkmar, anything you'd like to add to that?
Yeah, maybe I would like to. I have one further Darth Vader piece here, and I think that the comparison with the with this case, which is handled in 6 or 7 jurisdictions, this has never been reality, or only in the very big cases. And therefore, I would agree with Michael for the damage claims, because this is now really actually the first time where you can get damages for the what I would call remote countries in one court proceedings. But other than that, for the injunctive relief, it is certainly not true, because the reality was that the plaintiff went to one country or two, and then you have fought it out there, and then you got a judgment of one of the best recognized courts, and then the defendant would know how the other courts would decide if they go there. So that what we have seen in the good old days, so to say, was that we have had the cases in UK and Germany pending, and that was all for the injunctive relief. And as in Europe we are the continent of injunctive relief anyhow, at least the real continent, not the UK. The UK is like more like you in the US. But as we are dealing out the cases normally via the injunctive relief, this is less of importance here.
Yeah, and Volkmar just brought up an interesting thing. If you look at a map of where the Unified Patent Court and UP have effect, it's kind of a stripe of Europe, beginning in Finland and coming down, including France, and going on down to the Mediterranean at Italy. But left out are the UK and Spain, and most of Eastern Europe at the moment, for example, Poland and so forth, and Czechia. But eventually, there may be an expanded footprint of a total of 25 countries where this can potentially be in effect. Whether the UK ever becomes a part of it, we don't know. It's kind of always the situation with the UK. But in any case, that's interesting, because in the United States, before the creation of the CAFC, there was a lot of forum shopping. People would file in particular jurisdictions because there were some appellate courts in the United States in our federal system that had never held a patent valid. not unlike the Supreme Court, but had never held a patent valid. And so, people would file there because they knew that. And the CAFC tried to remedy that and at least create consistency, even if you didn't like the outcome. If you were on the losing side of something the CAFC affirmed, it was an unhappy day. All right, so let's talk about...
John, may I add one further element to this?
Sure.
What is now better from the German perspective, now leaving Darth Vader, confidentiality issues. In that regard, we in particular in Germany have been like a developing country. We have learned that only very late. We have learned it from the US, from the UK, where this differentiated scheme of then at the very end you have attorney's eyes only, a privilege and those things. It never played a really role in our practice, but it was being more and more cumbersome in practice in the last year. Now then we got a German law on that, but really it did not, it's still until today it does not really fit to our system. And my personal opinion now is that this works much better on the Unified Patent Court because we have a much more elaborated system. It gets to a regular practice to also have one eye on confidentiality issues. And that was before, it was always for everybody. For the courts, they did not know how to handle, they had to install confidential files aside, but the clerks didn't know how to move that around, and so on and so on. It was really bad. That is one of the elements where the influence, it's maybe from the UK, has positive effects.
And where I think the CMS actually provides for it from the start, from day one. It did provide for this, and that is, as you say, that's different from what it used to be in Germany.
Yeah.
Yeah, and for, in our acronym world, CMS is Case Management System.
Sorry.
Just so you know. Patent attorneys can have entire conversations with no words, just acronyms, and it's kind of fun but irritating to those who want to know what's going on. All right, so let's talk now about the awfulness of, here in the United States, we call it parallel proceedings, and that is, right now in the United States, if you file a patent case in a given jurisdiction and there's a subsequent proceeding initiated at the PTAB, the judge may or may not stop what they're doing and await the outcome of the PTAB. Now, there are rules where if you initiate at the PTAB, any subsequent district court action is stopped until the PTAB is resolved. But if you start first, and many cases start with a lawsuit, then a PTAB is initiated by a defendant. So how do you guys handle parallel proceedings, co-pending oppositions? Judge Fleuchaus.
I can't give any insights into what the court thinks about it. The European Patent Office has made a start and come up with rules, like issued by the President of the European Patent Office, how to deal with opposition procedures that are pending or parallel opposition procedures, and depending on when the European Patent Office is being informed about a pending case at the UPC or national court. So these guidelines essentially are drafted such that if the European Patent Office gets informed of a pending case, every deadline that the European Patent Office sets will be only minimum from that moment on, will be minimum deadline, and extensions will be rare, and the office really strives to hand down a decision as quickly as possible in any way. Whether that will in effect be leading to these quick decisions and still be good decisions by the European Patent Office, I can't tell. It's not this rule only came into force in November, and since then there haven't been too many of those cases in parallel with national procedures or UPC procedures. The deadlines are such that it may happen so that between the day of filing of the opposition through to the oral proceedings, there can be 5 months minimum. which for the patent holder may be a terribly short period of time if in a bigger case you expect multiple oppositions with multiple opponents. Then suddenly you've got 3 months time to respond to the opposition, potentially in the language that you're not familiar with, like opposition could be filed in French. You're a US company, so everything has to be translated back and forth. 5 or 3 months to respond to that, I think, is a superbly short amount of time. But it's what the European Patent Office wants, and they want to kind of make sure that the UPC doesn't decide through to the end in too many cases before they make a decision on the opposition. Because that's what happens. The UPC also has the possibility to stay a procedure and await the European Patent Office's decision. So far, that hasn't happened. So far, the UPC always decided through, basically with a view to the fact that the opposition procedure, including appeal, would be taking too long. But it may change. We'll see, and yeah, only time can tell. The UPC itself does not have a specific procedure or guidelines for this situation, and they couldn't because, as judges, of course, they're free to decide.
Right. Volkmar, anything you'd like to add about the parallel proceeding with co-pending things? Is there a strategy out there to just make the opposition, your opponent, spend money?
No, I don't think so. And anyhow, you have then to coordinate cases as we do before. Generally, the good news is, I think, that the UPC would still take the pace, and I would not see that they are waiting so long to the opposition, which is one of the main disadvantages seen from the patent owner side if you compare it with the old bifurcated system, which Michael has mentioned in his first round, where you then had really to wait 3 years until you got a decision. And by the way, from the patent court.
I see.
And by the way, this was actually the case. Also, one of the good things now for me, that this bifurcation is over, at least for this court system, I must admit. I was always going around in the international community here and having to defend the German bifurcated system. So of course at the end all the two branches came together to the same court. So in substantive law, all was good. We never had a final decision with diverging claim constructions, only on the lower courts. But in the last years, we have seen patent court, which has been very critical, and combined with the new law, which has provided that this court has to provide a qualified opinion really early, after 6 months of the service, in order to help the infringement court not to decide on an empty space, to help them make a look into the validity side. And this has turned out to be an injunctive gap backwards, because the qualified opinions have been very often negative for the patent, which then led to the case that the infringement cases have been stayed for 3 years until the full decision was there, because the infringement courts didn't want to decide against the competent authority. Right. And now we have this together in effective proceedings. Within 1 year, we have one decision on both sides, and that is also giving some. It eases this element eases the practical work, and it is also one of the elements where the expectations are confirmed. The agreement, the UPC agreement, still provides for the possibility that the infringement court is stayed, but in practice, the judges are happy to take both sides here, and at least the German courts, as we are seeing, they are taking both decisions together.
Okay. Next topic that I think is interesting, and it's an issue that we run into here in the States as well, and that is claim construction. Because here in the States, we have a presumption of validity in the courthouse, and we also have a fairly high level of proof, clear and convincing. And so if you're challenging a patent in the courthouse, it's a different thing. As opposed to at the patent office where there's no deference given to a presumption of validity, and the claim construction until recently has sort of taken that into account. It's not that the standard was so much different, because we've been told that the PTAB and the courthouse now have the same construction, claim construction standard, but they don't have the same level of proof. You know, we have more likely than not in the patent office, where that's your standard across the board. Our courthouse is clear and convincing. So on the claim construction front, do you anticipate any differences between how the EPO would look at a claim and the UPC?
There are differences. Up to this time of the UPC, the EPO has essentially not taken great care of the scope of the patent claim. So Article 69, which defines that the scope of the claim of the patent is defined by the claims, and due care has to be taken of the description and the drawings. That was applied in different ways by the European Patent Office. There were not even clear and harmonized Board of Appeal decisions on how much care should you be taking of the description, and say, for example, of definitions in the description. And so you had a bit of a, well, not a bit, you had differing approaches by the European Patent Office and, for example, the German courts in claim construction. Only very recently, the Unified Patent Court has handed down a decision by the Court of Appeals, basically confirming this wording of Article 69. So due care has to be taken of the description and the drawings in interpreting the claim. And the European Patent Office has just a couple of days ago decided to hand a decision up to the enlarged Board of Appeals to verify this whole concept at the European Patent Office. In mentioning that now, in view of the Unified Patent Court and the national patent courts, there should be a harmonized approach to that. Whether the enlarged Board of Appeal will take that harmonized approach and adopt what the Unified Patent Court now said, and very many national courts, by the way, also, that needs to show. I can't predict that. I would have guessed that it had happened like 20 years ago, but it didn't. So we'll see whether the chance is being taken up now.
Yeah, because it can get so bad here in the States that you have the CAFC affirming a district court and later affirming the patent office. The district court declaring the patent not invalid, and the PTAB declaring the patent invalid. And so you have exactly opposed decisions on the identical art, and it's affirmed by the same court. Different panel, mind you, but the same court. Pretty frustrating for us here. So next thing, and I'll put this to Volkmar, is, all right, so here in the States, you file a lawsuit, you succeed against one defendant, the patent passes muster, and now you want to go sue someone else. Well, you're in a different court. You got to go through all the same stuff. Everybody has another chance to challenge your patent at the PTAB. You know, it's starting over. So how do you suppose, or what's your anticipated outcome when you have a group of target companies and you want to sue them all one at a time? Is the Unified Patent Court going to make this efficient, like in a shooting gallery?
There is, yeah, exactly. And this question comes up when you are considering the competence of the respective local divisions. As you know, I think for the time being, 80% of the cases are pending in Germany, which is another story because we know the judges and we know what they are doing, so the predictability is better, I think, here in Germany. And now the question is always, if you have multiple defendants, how can you bring them all before a local chamber, even if they are domiciled in the United States? And the idea of the law, of the UPC agreement, is that you need one anchor defendant. If you have a group of companies acting together, then you need only one anchor defendant, how we call it, which then is the basis for the respective local chamber. And that is the response of the agreement, of the statutory law. There is now pending one interesting preliminary objection as to the question how long this anchor may be. So the regular situation, let's put it like this: you have a US-based mother company with a headquarter in the US and a German subsidiary. Then it is easy, no question about that. You can sue both, also the US company before the local German chamber. The question then is, if this group of company has another subsidiaries in Finland and Bulgaria and Portugal, this is my case. We believe that it is possible to include all this group then, because the anchor of the German also translates to the more remote subsidiaries, so to say, to the sister companies. But this is now one of these procedural questions where we need the wisdom of the court. It is pending. Not sure when it will be decided, but this is certainly one of the cases to be watched now for the next future.
Yeah, that's a fascinating issue. So some of these sister companies may well be in countries that are not covered by the UPC.
No, they are in UPC country, but not in a country where the German local division would be competent for.
Okay. Yeah, it's fascinating.
Hey, can I ask a question? And also remind you, if anybody in the audience has a question, just raise your hand. John asked you about parallel proceedings, and I want to ask you about sort of the same thing, but Germany versus the UPC. And I want to go back to something Judge Rader said yesterday. He was asked, where should you file cases? And Judge Rader said Dusseldorf, and then he also said Shenzhen. And I do think what we're seeing increasingly for patent owners who have enough at stake and can afford it is you're filing in the U.S., as Judge Rader says, because you want to settle under U.S. damages law. You're filing in Dusseldorf, you're filing in Shenzhen. Maybe for certain things you might be filing in Brazil. Maybe for other things you might be also filing in the UK. So you really have this worldwide press. And maybe even in the ITC, which we're going to talk about this afternoon. Do you see, how do you see the UPC fitting into that worldwide full court press for patent owners? And can you, I think I know the answer, but I'd like to hear, can you file both in the UPC and in Germany litigation on the same, it wouldn't be the same patent, obviously, but let's say the same family?
Who would you like to answer?
I'd like to, well, maybe both of you, but Judge, you can start first.
Okay, so if, for example, in the family you had a European patent with unitary effect plus a German national patent, you could sue based on both patents because with the unitary effect, the prohibition of double patenting was lifted. So you can now have a European patent with unitary effect that is applicable for Germany, and you can have a German national patent, both separate, both independent. One doesn't render the other ineffective, as it used to be the case with the European bundle patents.
And I would say you should have that, right?
I think it's advisable on your very, very important assets or very important inventions. I think it's well advisable to try these routes. The other case or the other question, how does the UPC fit into that scenario that was discussed yesterday? I'd say you could well replace either Düsseldorf with the UPC, or you could add the UPC as a third option to Düsseldorf, Shenzhen, UPC. You will, if you file at the UPC and you happen to get a chance to go to the Düsseldorf local chamber, you'll even see the same judges or some of the same judges sitting in the court.
Because the judges are all patent judges from throughout Europe that sit in countries.
Well, because the local chambers include some of the national patent judges, usually from these chambers, at least for now, at a partial time. So for now, many of the legal judges are, say, part-time UPC judges and part-time national judges.
Yeah. And the thought is as the UPC ramps up in cases, that's going to change.
That's
right?
going to change. For sure, it's already changing towards larger engagement of judges in the UPC.
Great. And I'll ask Volkmar, maybe, could you tell us when would you advise a client to be filing both in the UPC and in Germany? Or how does, from your perspective, how does this fit into the global full court press?
Actually, it's like having an additional bullet in the pistol. The actual decision depends really on so many factors. First of all, your portfolio. How many patents do you have? And obviously, you can't go with one and the same European patent to Düsseldorf local court and Düsseldorf UPC chamber. But if you are some of my clients are pools, and when we are, I would not say when then many licensors decide to go against one target, then what we are doing very often is to put two lawsuits at the UPC and having two pending at the Munich local chamber, the old one, the German ones, and in order to then not put all eggs in a basket. And actually what is really nice also in one of the expectations, which is confirmed, you mentioned that we see the same faces there, the same judges where we have had many, many cases before the national courts. We know how they are thinking. At least when it comes to the really crucial core themes like claim construction, we have had these struggles very often there, and now we are having the same struggles before the UPC.
And unwilling licensee, what they're going to think about that too.
And by the way, this is maybe also one of the cases to be watched now. How will the UPC interpret the friend obligations? That is one thing. In theory, we should have a harmonized law after the Huawei-ZTE decision, but at least the practice before the national courts and also in Germany, the practice really what really counts. When do you look to the friend of the patent owner? When do you look more to the behavior of the implementer? For those questions, we had seen a very developed, sure case law of the national divisions of the German court. Now how this plays out at the UPC is open. We know the immense impact that these decisions will have, but if you want to be on the safe harbor there, if you want to play your friend case as you played it before, then you would rather go at least from one patent to the Munich local chamber, which is still Munich National Court.
Okay, great. So we're down to about 7 minutes left in the segment. If anybody has a question, now is sort of the speak now or forever hold your question, or you could maybe ask it privately during lunch or whatever, before I give John the green light to go into the 7-minute drill.
The final round.
The final round. Okay. All right. Take it away, John. Thank you, guys.
All right. Thank you. So when we got started, Judge Fleuchaus mentioned this disembodied court. So how, practically speaking, does that work? There's no chambers for you to go to. Do you just pick up your phone? Do you go on Zoom? Tell us a day in the life of Judge Fleuchaus when you've been assigned to a case. How do you pull that off, the disembodied court?
It is mostly working on the case by yourself, as you would usually do, and rather than going next door, you will contact them on a video client that we're using, and discuss. There's quite an intense interaction amongst the judges. I mean, it's not ridiculously much, but there's a lot of interaction. Also, there are regular meetings between judges in different compositions. Like we have at least a monthly meeting amongst technical judges, where people are being obviously we're not talking cases, but people are being informed about news that are happening, and I think that's a very important thing, and that's a European-wide happening. So everybody is there, and I'd say, other than different dialects that are being used in the language, there doesn't seem to be any boundary there or border.
Oh, very good. Yeah, because it's interesting, because here in the States, of course, we think of a court, we think of a building somewhere, you know.
Yeah, there are buildings or there are courtrooms that are assigned to be used by the Unified Patent Court, but there is no big, nice and shiny court building that you can walk into. Place.
Yeah, well, the CAFC got away with it by relabeling a courthouse that already existed, so, you know, it can be done. So, Volkmar, what's it like litigating at this new UPC? Do you like it? Yeah. I mean, how's it working? Any practical issues that are difficult to work through?
Yeah, we talked enough about the CMS, which is really just leading to unnecessary work. No, it's really a pleasure. I would put here to the auditory one element which I personally like a lot. You know these judges, you know our understanding, our German, I must say, understanding of claim construction and procedural issues, and now you have the new umbrella of the new law. It is fascinating to see again how the old understanding translates to the new law. Let me put this on one example. What we really have as a practical problem is the service. So the service of the statement of claim, the very first phase. This is now also something to be watched in the next future, how this will play out. The problem is not to get it served to a German defendant. The problem is also not to get it served to a US company. You have this, it's called ABC Legal Authority, or it's a service I never understood, but it works. You have a delay of 4 weeks and then you are done. The problem is if you want to sue a Chinese company. And this is really near to impossible. It has been developed quite clearly by the German Munich chamber. They said, oh, you want to sue a Chinese company? We know that it does not work on the statutory level, even by diplomatic means, the A Convention and so on. Munich had developed a nice solution, nice for the patent owners, the so-called public service. You put just a letter in the court hall, and then it is deemed to be served after 4 weeks. Other local national divisions have developed other solutions. The Mannheim court, they had just continued with it against the German defendant. So you have to. The problem was to have one German subsidiary. Then you sued them. They have separated the Chinese case, and then you have just had the case against the German defendant, and then in nearly, actually all cases, the case was settled before the claim, the statement of claim was served to the Chinese company. Düsseldorf was playing a little different, tried to harmonize. They have tried to force the German defendant to bring in the mother company and so on. And what are we seeing now? The case law, the first case law of these three local divisions of the unitary patent, they are trying exactly the same before the UPC. We will see the first Board of Appeal decisions here. The Munich court, by the way, this was the most, they felt that they couldn't do it like before, but they have urged us, hey, please go to the Board of Appeal. We need to have this public service. We have to decide now to the negative, but please go there. We will have a hearing at the Board of Appeal in Luxembourg on 6th of June, and we will see how this goes out. It's a tiny side question, but so important for the practice to get everybody subject to the court, right? Not only the European companies and the US ones.
Right, because what I heard was American companies should create a Chinese subsidiary and do all their business in Europe through that. And then you can't be
that would be
sued.
the practical-
Excellent strategy. Let's start that here. All right, so we have no time left. So what I'm going to ask for each of you is to give your best 1 minute on the wonderfulness of the UPC, as it were your elevator pitch. Judge, go ahead. You first.
As Volkmar said, it's a new bullet in your gun. I'd say maybe, hopefully, a golden bullet. I think the UPC is going to be pretty successful, simply for reasons of the staff that has been pulled together, very capable staff, and the fact that the good things of the European countries were chipped in. I think it's a great court.
Me too. Volkmar?
I think I have not much to say. I give up, Darth Vader. It's exciting to be a patent litigator in these days, and we are experienced. And yeah, you are drawn back a little sometimes to the students' courses room and to have to rethink things which you have been able to advise also at midnight. But now everything is new. It's very exciting. Go for it. We see the impact of the decisions, and nowadays we can sure that it will be a success, the system.
Yeah, my view is that this is the biggest leap forward in pan-European patent protection and enforcement since the creation of the EPO. It's just a fantastic day in Europe. It makes it more efficient. It makes it faster. It makes it everything. And where there's action, there's economics. And so I think the UPC, I wish it well. And thank you guys for coming by. So
Thank you, John.
thank you.
Thank you.
Great. Thank you very much. Thank you. So we safely went.